SJC-13643, Lorraine Bellmar, personal representative, versus Robert Moore and another.
Attorney Beerhans.
Good morning, Justices. May it please the Court. Bruce Beerens for the appellant Lorraine Bellmar. Respectfully, the issue before the Court this morning is whether or not the 2022 Moran decision from the Appeals Court bars recovery under the statute of repose where the plaintiff has, in fact, proven duty, breach, and causation within the statute of repose. And this is interpreting MGL Chapter 260, Section 4. We assert that the statute and the case law does not bar recovery and that we have convincingly established duty, breach, and causation, and that the harsh result discussed in our cases is not warranted in this case.
So I'm trying to find out what happened below as far as the factual allegations. In particular, I'm going through the expert disclosures.
Correct.
And as I read it, it's all hinged on the December 8th, 2006 EKG abnormal results attendant to hypertension. Other than the sequence of 10 years of caring for him, where do we get, because it can't be continuing treatment, so where do we get a cause of action that is different from or is extended from the December 8th, 2006 event?
We don't believe, Judge, that this is a continuing treatment case or that the continuing treatment doctrine is applicable to the treatment in this particular case. Our position is that while the 2006 abnormal EKG is an event, it is not an event that bars recovery under the statute because there was continuing treatment, but our position is that each visit of the 13 visits over a 10-year period that did not or failed to address the multiple constellation of symptoms in this case, each of those treatments constituted a distinct and separate event which tolls the statute of repose in this particular case. And that really is the gist of the plaintiff's argument in this case.
But don't you need a separate act of negligence, right? Justice Gaziano is saying, I'm reading through the expert's report, and it's focused on the one outside of the EKG, outside of the statute. Don't you need some separate act of negligence that's not dependent on that to keep this case alive? Because it's not just that you kept missing that EKG point. You need something separate, right? We've said that, at least the appeals court said that clearly.
Yes.
So what's separate? What was the separate independent act of negligence that happened during the time period?
Based on Dr. Pell's testimony, not only in his 3 reports, but in this case, we have the benefit of a full-day Daubert hearing, which we don't normally have, and that's admittedly pretty rare, I think. In this particular case, Dr. Pell has made clear that each visit between 2006 and 2016 at the time of death is, in fact, an independent event that tolls the statute of repose.
But again, I mean, and Justice Gaziano knows the expert report better than I do, but my understanding of it is that he's overweight, and there are other things, but nothing, if you ignore the EKG, which it's too late, doesn't one of those visits have to be negligent itself? Okay, he's heavy and his blood pressure is this, but that doesn't say that you should do anything, from what I understand. You need that missing EKG each time.
Well, not necessarily. As Dr. Pels has also testified in this case, that even if the 2006 EKG was normal and not abnormal, the constellation of symptoms required continuing follow-up, continuing testing, continuing treatment, and additionally, he also talks at length about the issue of various medications that could have prevented the death.
Counselor, this is important to me, Lisa. Where can we find that? What do you cite for that proposition?
In multiple places. Dr. Pelz testifies that,
This is in the Darby hearing?
yes, in the Dalbert hearing, he testifies at page 109 and 110 in volume 2. He testifies in volume 2, page 138, that the multiple risk factors and the abnormal EKG and the signs and symptoms.
That's the problem, right?
It's always, as I read, it's always going back to the 2006 EKG.
No, if I may, can I read his ultimate opinion from the Dalbert?
Sure, please.
From the Dalbert hearing. After he testifies about all of the various treatments that were available based upon this constellation of symptoms, towards the end of his testimony in the Dalbert hearing, my question is, and doctor, based upon your review of the medical records and the autopsy report, recognizing, by the way, that when he died, his heart was 800 grams as compared to the normal size of a normal heart, which is approximately 300 grams. And your experience, as you've described it, treating thousands of patients with cardiac diseases, do you have an opinion to a reasonable medical certainty as to what the standard of care required that the qualified internist do to treat Mr. Bellmar's cardiac health between 2006 and 2016? Yes, I do. And what should he have done? Dr. Moore should have obtained an EKG, and based on the findings of that EKG, either proceeded with additional cardiac testing that would have been indicated or refer the patient to a consulting heart specialist, a cardiologist. And was that done in this case? No, neither was done. And doctor, based upon the documents that you've reviewed in this case and your experience as you've described it, do you have an opinion to a reasonable medical certainty as to the cause of Mr. Bellmar's death? Yes, I do. And what is the cause of his death? The cause of death was a cardiac arrest. And do you have an opinion to a reasonable medical certainty as to whether or not his death was preventable if he had been treated as you described? Yes, I do. And what is your opinion? It is my opinion that if Mr. Bellmar had been appropriately evaluated and treated according to the standard of care, that his death would have been preventable. I don't know that a plaintiff trying a medical negligence case can do more than this. And it's clear based upon his testimony that that standard of care was not adhered to during the entire period between 2006 and 2016.
The 2006 includes the EKG, though, right?
Excuse me?
When you say, I mean, you said from between 2006 and 2016, that includes the EKG that's missed, right? It's not, you didn't ask, okay, forget about the EKG. When he shows up heavy and blankety blank, should there have been another EKG, or should there have been I mean, you may have done this. It's a question, not an answer. Did you point, because you can't rely on that EKG. So you need to somehow find negligence separate and apart from the fact that they missed that EKG, right?
Yes, and that's the point that Dr. Pelz was trying to make.
When you frame the question as 2006, doesn't that incorporate the EKG?
Certainly, and there's nothing wrong with incorporating the EKG.
Well, but I understand he wants to use the failure on the EKG in 2006. I get it. That can't end things. But it seems to me you're still relying on it in that question, because the doctor is the expert is building in the fact that you had this EKG and you should have done something, don't you have to ask, separate and apart from that, should he have done something without any knowledge of that EKG?
Yes, and I would point again to Volume 2, page 109 to page 110, where Dr. Pelz testified that even if Mr. Bellmar had a normal EKG in 2006, his multiple risk factors warranted the performance of a follow-up EKG and additional testing because these conditions worsen over time.
Where is that? Sorry, it's volume 2, what?
Volume 2, page 109 to 110. And I can read my question, which I think answers.
No, we have, we'll look it up if we have any. I don't want to waste your time reading to us.
So I think that it's clear you have an individual, I hate to use the word obese, but he's over 300 pounds. He has hypertension, he has sleep apnea, and over a 10-year period, no testing is done such that treatment would be warranted to somehow prevent this death.
So if we read the Darby hearing as carefully as you have, we'll come to the conclusion that someone who presents overweight, hypertension with sleep apnea should have had cardiac follow-up.
Absolutely. Each and every time, over 13 visits over a 10-year period. And this is not a situation like in the Moran case where there was a 6-year gap in treatment. He continued with this constellation of symptoms to go to the doctor twice every year over a 10-year period. And nothing was done. And I think what frankly I find most disturbing about this case is not only Dr. Kinsfogel, but Dr. Moore himself. Dr. Kinsfogel, the defendant's expert, testified that notwithstanding all of these symptoms, his death was not foreseeable. It was not preventable. Dr. Moore testified that notwithstanding all of these symptoms, he was no more at risk for a cardiac incident than the average person. That's absurd. That's for the jury to decide. But to suggest that this particular individual was going to die no matter what, that's simply not credible at all. And that's why the case needs to go to a jury.
Okay, thank you.
I have nothing further. Thank you very much.
Attorney O'Shea.
Morning, Your Honors. Stephen O'Shea on behalf of Dr. Moore and Dr. Moore's PC. With me today is Alexis Harrington from my office. To touch upon the question about is there anything other than the EKG, there really isn't.
Well, let me read you exactly what he just said. Okay, and even if he had had a normal EKG in 2006, would his underlying risk factors warrant the performance of a follow-up EKG? Yes, it would. And why is that? Because these conditions can predispose him to cardiac disease and can worsen over time.
Right.
But he's saying, he asked the question I just asked.
Yep.
Basically, okay, if the EKG was normal in 2006 and not abnormal, would you still have to do these subsequent EKGs? Isn't that a separate act of negligence?
No, it's not, for two reasons. And the first one, and the appeals court actually addressed that in its decision at the very end. The key word in that question was warrants. There is no standard of care opinion question that you just read. He's not saying, based upon a reasonable degree of medical certainty, take out the EKG and he's presenting with these signs. The standard of care of the average qualified internal medicine practitioner would have required him. He's saying warrants.
Well, is
But
it?
Would
I
have
know.
required him.
Counsel, but doesn't Dr. Pell's report extensively discuss the standard of care in the Record Appendix 1 there's a bunch of he had 3 reports, but at RA 154, the Dr. Pell's, I think maybe second report, goes through the standard of care for someone with all of Mr. Bellmar's conditions and says that he should have gotten testing.
Always tied in every one of those reports to the EKG. the EKG and his underlying cardiac risk factors, which, by the way, all 4 of them were pre-2010.
But just let me, I'm sorry, go ahead.
Go ahead, I was just.
Didn't the expert also opine that there was a flaw in the treatment in that Dr. Moore never ordered another EKG? Isn't that exactly the testimony that Justice Kafker was alluding to as well?
That is the alleged negligence, is that the EKG was abnormal.
No, this is separate, I think. It's a statement that not ordering another one within the statute of repose period was also negligent.
Which is hinged to the EKG.
Why does that matter? It seems to me that you're proposing a standard that would say it's okay for a doctor when making a decision whether to, or actually it's required for a doctor when making a decision whether to order a test to ignore the events that preceded that. Why is it that a doctor shouldn't be required when deciding whether to order a test to look at the results of a previous test as well?
I think the issue is the statute of repose once it starts to tick. And in this case, it starts to tick in 2006, when Dr. Moore receives that EKG on December 13th and does not order a test, even in light of those cardiac risk factors. That claim is now ticking. And if the
only cases you cite for this proposition are failure to diagnose cases. And that's not what this case at bottom is. This case at bottom, as I understand the theory, is a failure to test, to order tests.
I think it's a failure to diagnose, do the test to make a diagnosis of
Right,
cardiac
so
disease.
in Rudenauer, for example, and in Morin, the tests were performed. And then the doctor looked over and over. There were tests repeatedly performed, and the doctor failed to diagnose. And we said that was a continuing stream of treatment, and therefore the statute of repose applied. But here, we don't have that. We don't have a continuous stream of treatment. We have a lack of treatment. We have plenty of visits in which the doctor doesn't perform the initial test. And I think that's the crux of the theory of negligence.
Okay, and I'd fall back to the language in the statute. And the question really, if you're exploring modifying or overruling Moran, which I think this case is on all fours with, would be, are you entertaining the thought of multiple definitively established events?
If the
Or
doctor,
is it just the one?
if the patient had, let's assume all facts the same, except the following fact, that the patient decides to choose doctors, to change doctors, at some point that would be within the statute of repose. Could the patient bring a claim against the second doctor?
Sure, if there's an expert who's going to testify that that
As I said,
doctor
everything
deviated
the
from
same.
standard of care.
Everything the same. So in essence, isn't your rule leading to the conclusion that the failure here was the patient's failure to switch doctors?
No.
Why not?
I mean, the issue in the case is whether the statute of repose bars this claim,
But it wouldn't bar the claim if the doctor were different.
right?
Well, and I mean, it's a particularly different with Moran, where, so not only was this years earlier, but I believe the experts, and you can correct me if this is actually wrong, but the expert report suggests that this old EKG from 2006 was not even in the doctor's records for this patient. Is that correct?
Which was not true. It was, and he realized it later.
So that was
In
corrected?
the Dalbert hearing, we clarified
Okay,
that.
thank
And it's
you.
actually in the opinion as well.
Thank you.
Yeah. I would say, really, the issue is this continuing treatment, or are there separate independent, definitively established events after December 6 or December 13 of 2006 that you can point to with expert medical testimony to support a claim against Dr. Moore? And the answer is no. The closest they get, and even if you take that language of the testing would have been warranted if just based on the independent factors alone, the cardiac risk factors, those existed in 2006. It's the same case. It's the same claim. Every visit, it's the same exact claim. There is nothing to distinguish 2007, 8, 9, 10, 11, 12, all the way to 2015 from 2006. And so if
Except it's a new opportunity for the doctor to actually correct the mistake.
here's the rub, right? So if Mr. Bellmar had come in with highly elevated blood pressures and Dr. Moore didn't do anything about it, that's an independent basis to say, hey, wait a minute, that's a new claim. If he had high LDL, which Dr. Moore was checking on a regular basis, and they were all within normal limits, if he ignored that, that's an independent basis to bring a claim against Dr. Moore. If he came in and said, I have crushing chest pain every day of the week for the last month, that's an independent basis to bring a claim against Dr. Moore.
What was the shortness of breath that led to a stress test, I think?
There was a reference in the record. He came in on one occasion and said that he had some tightness.
Tightness in the chest,
And I asked Dr. Pels, did he have any symptoms that would have warranted testing? And he said no. The reason he needed the testing was because of the EKG and the underlying cardiac risk factors. No symptoms at all. They raised the issue of the CIMT test and whether there were some abnormalities.
That's in the Daubert hearing?
Yes.
Okay.
And it's partially in the Pels reports as well. And he admitted that the CIMT test did not warrant testing. He kept going back. The only reason to do it is because of the abnormal EKG and the underlying cardiac risk factors, which existed in 2006. And by the way, Pels admitted Dr. Moore took great care. Dr. Moore took great care of Mr. Bellmar, looking at it without the benefit of that testing. And he only says if the testing had been done and the testing had showed cardiac disease, then we might treat him differently. But without that information, Dr. Moore was doing great as far as his care and treatment.
You seem to have, before when you were talking about if he had come in with such and such urgent urgent situation, then he might have had to do something. And it made me think that you're essentially making an argument that it can't be negligent to not engage in preventive care, because that is essentially what we're talking about right here. There's a man who has many, many risk factors, and preventive care would involve, this Dr. Pels is saying, giving tests to make sure there's not something else going on. Is there any basis in law for that?
What I'm saying is that you can't take the claim and read the statute. It's in no event shall any action be commenced more than 7 years after occurrence of the act, singular, or omission, which is the alleged cause of the injury upon which such action is based. So the issue is not whether it's preventative care or not. Is the claim downstream the same claim as the first one?
Well, I think the claim is the omission of preventive care for all the years from after the EKG onward.
Frankly, we don't have that here, because he's always looping in the EKG. It's not just he failed to provide adequate preventative care. There was an abnormal EKG in 2006. That abnormal EKG, coupled with all of those cardiac risk factors, should have caused him to do these things.
And you don't think the omission of a subsequent EKG is enough?
But what?
The omission in the 10-year period between 2006 and 2016, the omission, the failure to order another EKG, you don't think that would be enough to sustain the claim?
No, because that's what he was saying in 2006.
No, I mean, it's a little different, right? The 2006, I understand that the statute of repose has run on that, but now we have a doctor who has repeated opportunities to do another EKG, and according to the expert, that was warranted. that would have then given him the information that he would have needed in order to correct course.
Right, which is what he's saying in 2006.
But there's one other component to that, and you haven't mentioned this. 10 years elapse.
Yeah.
I mean, the idea that for a lot of us, the older we get, the worse off we get. So the idea you kept pointing to, there's no thing that came in to say, hey, maybe this is the reason why we should order a subsequent EKG. You come in, shortness of breath, or is there some other physical thing that happens to trigger a new look and not just be relying on 2006? Why not just age? Why not just age? I mean, if you have a 40-year-old with all of these underlying physical conditions, certainly being 45 makes it a little bit worse. Being 47 makes it a little bit worse, and being 50 makes it a little bit worse. So why wouldn't all of these things say, you can't just keep going back and saying you are as you were in 2006 for all time?
That's in part a standard of care question that Pell's never addressed. So there's no expert testimony in the record to suggest that that would have been required. And I would say, lastly, there was a secondary argument in support of the summary judgment motion, which I think is equally as persuasive as the first, and that is the causation issue. And it is in Rudenauer. It's the basis of the Rudenauer decision. They addressed the fact that there was this other complaint in 1995 that would have been within 7 years of the filing of the complaint. And so this court looked at that and said, well, wait a minute, there's no expert support to say that if something had been done at that time, it would have made a difference. In this case, it's very, very similar. I asked Dr. Pelz, when did the microscopic fibrosis that triggered the cardiac arrhythmia happen? Open-ended question. And he said, I can't say precisely. That's not something that we know. And so I went further. I said, well, could it have happened in 2006? Could it have been there already? Yes, it could have. 2007? Yes, it could have. 2008? Yes, it could have. 2009? Yes, it could have. 2010? Yes, it could have. He never rendered an opinion as to when that happened, and it's the plaintiff's burden of proof to show that their claim is not barred by the statute of repose. And to do that, he would have had to have rendered an opinion based upon a reasonable degree of medical certainty that Dr. Moore's failures after 2010, at the latest, December 13, 2010, caused Mr. Bellmar's
Would a
death.
subsequent EKG have shown when that particular condition you were referring to began?
My cardiologist said not only would an EKG not have done it, an echocardiogram wouldn't have done it. It wouldn't have been picked up on any type of testing other than a cardiac MRI, maybe. And there are very special indications for doing a cardiac MRI. So it probably never would have been picked up.
So you would have needed a test.
What's that?
So one would have needed a test.
And questionably whether even if you did that kind of a test, it would have been detectable. It was 3 millimeters, less than 1/2 centimeter. Most of those tests don't have that high resolution.